Hello live law viewers, welcome back to part 2 of our special series on 100 important judgments of the Supreme Court from 2024. I am your host Urvashi Chauhan, bringing to you the crucial decisions that have made a significant impact on the public and are a valuable resource for the legal professionals and students. Part 1 covering the first 25 judgments is already out and you can check it on our channel. I will tell you in brief about the judgment. We will display the citation and title also for you on the screen. For detailed reading, you can always refer to complete coverage on our website at www.livelaw.in. Let us start with part 2. In an important development, the bench of Justices Rishikesh Roy and Prashant Kumar Mishra in Abhimit Sinha versus High Court of Patna had held that constitutionality of rules stipulating minimum qualifying marks in the viva voce test as part of selection criteria for appointment to district judiciary in states of Bihar and Gujarat. The Supreme Court, in a pivotal order passed by the bench comprising Justices Hima Kohli and Ehsanuddin Amanullah, laid down a slew of measures to protect consumers from misleading advertisements. The directions included equal responsibility of advertisers and endorsers with regard to misleading ads and the uploading of a self-declaration form by advertisers before issuing any advertisements. The court declared this in Indian Medical Association versus Union of India that the fundamental right to health encompasses the right of a consumer to be made aware of quality of products being offered for sale by manufacturers, service providers, advertisers, and advertising agencies. Next, in Colonel Ramneesh Pal Singh versus Sugandhi Agarwal, the bench of Justices Vikram Nath and Satish Chandra Sharma discussed the concept of Parental Alienation Syndrome or PAS. This was in a case between an estranged couple for the custody of their children. Let me tell you, PAS is a syndrome whereby one parent who has custody of the child promotes feelings of disaffection against the other parent in the mind of the child, which ultimately influences the child's preference for one parent in a court litigation for custody. Moving ahead, the bench of Justices Suryakant and K.V. Vishwanathan referred to a 3-judge bench the question of whether debts that are time-barred under the Limitation Act of 1963 and therefore cannot be recovered through civil suits can still be recovered by utilizing alternative remedies available under special statutes for debt recovery. The title of this case is KP Khemka versus Haryana State Industrial and Infrastructure Corporation Limited and others. In another case, the bench of Justice C.T. Ravi Kumar and Justice Rajesh Bindal observed that Juvenile Justice Care and Protection of Children Act 2015 does not specify a time limit for filing an appeal against the preliminary assessment order of the Juvenile Justice Board. To address this gap, the bench in this case deemed it appropriate to establish a 30-day time limit for filing such appeals. Next is one of the most significant updates from this year. That is the case of State of Punjab and others versus Devinder Singh and others. In this, a 7-judge bench of the Supreme Court by a ratio of 6:1 held that subclassification of scheduled castes is permissible to grant separate quotas for more backward within the scheduled caste categories. The verdict means that states can identify more backward among the scheduled caste categories and can subclassify them for separate quota within the quota. The bench comprising of then CJI D.Y. Chandrachud, Justices B.R. Gawai, Vikram Nath, Bela M. Trivedi, Pankaj Mittal, Manoj Mishra and Satish Chandra Sharma clarified that while allowing subclassification, the state cannot earmark 100% reservation for a subclass. Also, the state has to justify the subclassification on the basis of empirical data regarding the inadequacy of representation of the subclass. 4 judges of the majority also opined that the creamy layer among scheduled castes must be identified and excluded from quotas. Also, Justice Bela M. Trivedi dissented. In another notable judgment, the Supreme Court ruled that advocates cannot be held liable under the Consumer Protection Act for deficiency in services. The court emphasized that professionals should be treated differently from those engaged in business or trade. The judgment was delivered by a bench comprising Justices Bela M. Trivedi and Pankaj Mittal. The title of this case is Bar of Indian Lawyers versus D.K. Gandhi PS National Institute of Communicable Diseases. In a major development, the bench of Justices B.R. Gawai and Sandeep Mehta, while passing judgment in Prabir Purkayast versus State declared the arrest of NewsClick founder and editor-in-chief Prabir Purkayast by the Delhi police along with his remand in a case under UAPA as illegal. The court held that principles established in the Pankaj Bansal judgment requiring written reasons for an arrest apply to UAPA cases as well. It further stated that an illegal arrest cannot be legitimized by the issuance of a remand order. Next, the Supreme Court, in a judgment authored by the then CJI D.Y. Chandrachud and delivered by a bench also comprising Justices J.B. Pardewala and Manoj Mishra, recognized the right to be free from the adverse effects of climate change as a distinct constitutional right. The court identified Articles 14 and 21 of the Indian Constitution as the key sources of this right. In Kolkata Municipal Corporation and another versus V. Bimal Kumar Shah, the Supreme Court, while setting aside acquisition of land acquired by Kolkata Municipal Corporation Act 1980, highlighted 7 sub-rights of the Article 300A of the Constitution. Let me tell you, Article 300A provides that no person shall be deprived of his property save by authority of law. The judgment authored by Justice P.S. Narasimha from the bench along with Justice Arvind Kumar stressed that these sub-rights mark the real content of the right to property under Article 300A. Non-compliance of these will amount to a violation of the right being without the authority of law. Coming to the next update, the Supreme Court cautioned 2 members of National Consumer Disputes Redressal Commission for issuing non-bailable warrants against the directors of a company, ignoring a previous interim order of the Supreme Court. The bench, comprising Justices Hima Kohli and Ehsanuddin Amanullah, while closing the contempt proceedings initiated against them, categorically marked that all orders passed by the top court ought to be respected and fully complied with. It continued to say that hierarchy of judiciary needs to be respected, and in that hierarchy, the order passed by the top court will bind the NCDRC as well as judicial officers. Next, the bench of Justices J.B. Pardewala and Manoj Mishra held that an order for the convict to pay compensation to the victim would not result in reduction of the sentence imposed on that convict. The court took note of the scheme of Section 357 of CRPC, which intends to reassure the victim that he or she is not forgotten in the criminal justice system. In a landmark judgment delivered by Justices Abhay S. Oak and Ujjal Bhuya in the case of Tarseem Lal versus Directorate of Enforcement, it was held that ED and its officers cannot exercise powers under Section 19 of Prevention of Money Laundering Act to arrest an accused after the special court has taken cognizance of a money laundering complaint. In another significant ruling, the Supreme Court has upheld a rule issued by Institute of Chartered Accountants of India, which prohibits chartered accountants from accepting more than the specified number of tax audit assignments, currently set at maximum of 60 in a financial year. The judgment was delivered by a bench of Justices B.V. Nagratna and Augustine George Massey, and the title is Shaji Palos versus Institute of Chartered Accountants of India. Moving ahead, the bench, comprising Justices J.K. Maheshwari and K.V. Vishwanathan in Ankur Chaudhary versus State of Madhya Pradesh, observed that if there is an undue delay in completion of the trial, then there would be no impediment to consider the grant of bail to the accused under Narcotics, Drugs and Psychotropic Substances Act, despite not meeting the stringent test under Section 37 of the NDPS Act. The Supreme Court in another case held that there cannot be a bail condition that enables the police to constantly track the movements of the accused and virtually peep into the privacy of the accused. This was the case of Frank Vitus versus Narcotics Control Bureau. A bench of Justice Abhay S. Oak and Justice Ujjal Bhuya was examining whether a bail condition requiring an accused to drop a pin on Google Maps for investigating officer to access his location violates a person's right to privacy. In a notable judgment delivered in Nipun Malhotra versus Sony Pictures Films India Private Limited, the Supreme Court issued a set of guidelines to the visual media to ensure a dignified portrayal of persons with disabilities. The court stressed that portrayals which carry negative stereotypes about persons with disabilities would impact their dignity and perpetuate social discrimination against them. A bench comprising then CJI D.Y. Chandrachud, Justices J.B. Pardewala and Manoj Mishra was hearing a challenge to the portrayal of disabled persons in the film Aankh Micholi produced by Sony Pictures. Expressing displeasure over filing of bulky and lengthy submissions in arbitral proceedings, the Supreme Court bench comprising Justices Abhay S. Oak and Pankaj Mittal in Bombay Slum Redevelopment Corporation Private Limited versus Sameer Narayan Bhojwani called upon the bar to urge only the legally permissible grounds in the arbitration proceedings carried under sections 34 and 37 of the Arbitration and Conciliation Act 1996. In another important case, the Supreme Court determined that State of West Bengal's lawsuit against Union regarding CBI's registration of cases despite revocation of its general consent is maintainable. Dismissing the preliminary objections raised by the Union, the bench comprising Justices B.R. Gawai and Sandeep Mehta concluded in this case of State of West Bengal versus Union of India that the state's plaint presented a valid cause of action. Next is an important ruling in the case of Mohammad Abdul Samad versus the state of Telangana, where the court held that a divorced Muslim woman is entitled to file a petition for maintenance against her ex-husband under Section 125 of CRPC. The bench of Justices B.V. Nagratna and Augustine George Massey held that this right of a Muslim woman is in addition to the right under Muslim Women Protection of Rights on Divorce Act of 1986. The Supreme Court in the matter of Muhammad Rahim Ali versus State of Assam held that authorities cannot randomly accuse people of being foreigners and initiate investigation into a person's nationality without existence of material basis or information for suspicion. The matter was decided by a bench of Justice Vikram Nath and Justice Ehsanuddin Amanullah. In an important update, the bench consisting Justices Sanjiv Khanna and Dipankar Datta granted interim bail to then Delhi Chief Minister Arvind Kejriwal in the case registered under Prevention of Money Laundering Act over the liquor policy case, while referring his petition challenging arrest by Enforcement Directorate to a larger bench. The title of this case is Arvind Kejriwal versus Directorate of Enforcement. The Supreme Court in Central Information Commission versus DDA has held that Chief Information Commissioner has the power to form benches and frame regulations for the effective management of affairs of Central Information Commission under Section 12, subsection 4 of the Right to Information Act. A bench of Justice Vikram Nath and Justice Satish Chandra Sharma in this case underscored the importance of Commission's autonomy for its effective functioning, stressing that undue interference in its administrative functions would impede its ability to handle a large volume of cases efficiently. The bench of Justices Vikram Nath and Prashant Kumar Mishra in the case of Dr. Bhimrao Ambedkar Vichar Manch Bihar versus the state of Bihar struck down the resolution issued by Bihar government in the year 2015, which had merged one community in the backward caste list with another community in the scheduled caste list. The court held that the state government had no competence or authority to tinker with the lists of scheduled castes published under Article 341 of the Constitution. And the apex court in the matter of Shailendra Kumar Srivastav versus the state of Uttar Pradesh held that prosecution of a gruesome crime of double murder cannot be withdrawn by the state on mere ground that the accused has a good public image, being an elected representative. The quorum of the bench comprised of Justices Vikram Nath and Satish Chandra Sharma. With that, we come to the end of part 2 of this series. Please make sure to like, share and comment, and also subscribe to our channel. Stay tuned for part 3.